Hi guys, how are you doing? Alright, I'm filming this for a variety of reasons. Number one is for your review, so that you can always come back and utilize this tape to review for this class. Two is because since some of you are going to New York, I want to make sure that they have the tools necessary, both at hand and online, to be able to be prepared for the coming quarterlies. Now, we're going to go over two sections, and they're in chapter 7, section 2, and 7, section 3. You may recall, we've already started talking about the law and what the law is and the legal system. Now we're going to focus more on the legal system in the United States. Section 1 was the legal system throughout the world, how the law came into being. And as you may recall, we talked about King Hammurabi, and we talked about the Ten Commandments and the creation of law and why it is that societies need to have laws. Section 2 is about the federal court system. But before we get to talking about the federal court system, you should know a couple of preliminary things. Number one, every state has two, not one, two different courts. They have state courts and federal courts. You're probably saying, but why do we have two court systems? Why can't we just have one? Well, you may recall that when we're talking about Congress and the powers of Congress, Congress is a limited government. It only has the power to do 18 things. You find the powers of Congress in Article 1, Section 8, clauses 1 through 18. All other powers, and I'm talking about everything else, is left to the states. So in order to protect or safeguard the state and its citizens, the states have seen it necessary to create their individual courts or independent courts. As a matter of fact, state courts are much older, since they were in effect before the Constitution, than federal courts. But we're going to focus on the concept of federal courts. You need to understand that courts have different levels. Think or envision in your mind a pyramid. Okay? At the very ground level, you have courts that are intended to solve problems. If there's a problem in society, whether it's a criminal problem or a state problem, people bring those problems to courts. Those courts are called, by nickname, trial courts. Trial courts are the ones that you're probably the most familiar with, because as you turn on the television and you watch crime dramas, those are the courts that are most popular. There, you're going to find a judge, you're going to find a jury, you're going to find lawyers that are showing evidence, you're going to talk about or think about witnesses, and so on. And at the very end, you have a jury determination, a verdict. Was the person guilty or innocent? The same sort of drama happens in civil court, except there isn't a punishment, like a sentence, that's given at the very end. In civil courts, the things that are dealt with, or the matters that are resolved, are civil disputes, disputes between people. Someone has a problem with somebody else, they bring it to court, there is a trial, and at the very end, the jury makes a determination as to who's right and who's wrong. Oftentimes, the jury awards money in compensation for somebody who has been damaged. For example, in an automobile accident, if the person that was injured sues the person that was responsible for the accident, at the end, a jury might determine that the person responsible for the injury should pay a certain amount to help out the person that was injured. Okay? That's the first level. And those courts, by nickname, are called trial courts, because trials take place there. Then the next level up, you have what are called appellate courts. Appellate courts are different than trial courts. Number one, all that drama that is very popular on television is not present in appellate courts. You don't have juries, you don't have witnesses, you don't have evidence. The whole function and purpose of an appellate court is to determine if what happened at the trial court during the trial was correct, if there was any error. You see, we're very worried about making sure that trials are fair. So the appellate court's function is to verify that there is a fairness that has taken place and that no errors, at least errors bad enough to have affected the outcome, have taken place. Generally, in an appellate court, you're going to find 3 judges, Okay? And just the attorneys who are arguing the legal points that are being presented. This was an error, and therefore, appellate court, you should reverse, make them try it again. The other side is saying there was no error, and therefore, appellate court, you should affirm. Affirm means to stamp as correct the determination of the court below. Okay? And at the very top of this court system, at the top of the pyramid, you have the Supreme Court. The Supreme Court is a court that very rarely acts on cases. Why? Because the Supreme Court is not intended to be a court that reviews every single case. The Supreme Court only acts in very special matters. For example, in a matter where different appellate courts from different places decide a similar case differently, the Supreme Court might intervene to say this one was right and that one was wrong. Because the function of the Supreme Court is to make sure that all of the underlying courts, the courts that fall below, are doing the same thing, so that the law is not different in one side of the country or one side of the state from another, and everybody is treated fairly. The Supreme Court will also handle special cases, cases of very important matters. For example, in the federal court system, there came a time when the Supreme Court had to intervene and say that segregation, that is the division of the races within the United States, was wrong. And in the case of Brown versus Board of Education of Topeka, Kansas, the Supreme Court of the United States basically said no more segregation, no more division of races. So as of that moment, the United States had to integrate. And that is generally the function of the Supreme Court. Okay? And that is true of both state system and federal system. Now, let's step back a little bit and talk just about the federal courts. First of all, the federal courts are not, by and large, created in the Constitution. You may recall that the presidency, who the president is, and what is his credentials to be president, how old, how long he's lived in the United States, whether he's natural born or not, is in the Constitution. Same thing for Congress. Who can be a congressperson, who can be a representative, who can be a senator, is all set in the Constitution. Now, there is no such thing for the courts. The Constitution creates one court, creates just one. It creates the Supreme Court of the United States. Whereas in Article 1, Congress is created, and in Article 2, the executive branch, which includes the president, is created. In Article 3, the Constitution creates the Supreme Court. Now, that's all it does. However, there is language in Article 3 that says that Congress, depending on its will and the need in the country, can create inferior courts. Inferior from what? From the Supreme Court. So Congress creates appellate courts and trial courts that are inferior to the Supreme Court. Okay? So there's only the creation of one court. Now, what cases are tried, what cases are resolved in federal courts? Number one, cases that deal with federal law. Any of those 18 things, that Congress has passed a law and that has been violated or parties are disputing can go to federal court. The second thing that can be resolved in federal courts are cases where it involves state law, but it involves citizens of different states. Let's say that somebody in Florida is suing somebody in Georgia, and the amount that is being disputed by the person in Florida and the person in Georgia is over $75,000, 75000, then the parties can bring the case in federal court. And you're probably asking,
I have Spanish test now.
and hey, let's cut.